Further, the victim impact statement is another important factor that the court has to take into account as it deals with the impact of crime on the victims. In the case of State versus Matiti, 695 of 2009, 2010 ZASCA 127, 30th of September 2010, the Supreme Court of Appeal of South Africa, where it was stated by the Honorable Judges at page 11, open quotes, by accommodating the victim during the sentencing process, the court will be better informed before sentence about the after effects of the crime. The court will thus have at its disposal information pertaining to both the accused and victim, and in that way, hopefully, a more balanced approach to sentencing can be achieved. Absent evidence from the victim, the court will have half of the information necessary to properly exercise its sentencing discretion. It is thus important that information pertaining not just to the objective gravity of the offense, but also the impact of the crime on the victim, be placed before the court. That in turn will contribute to the achievement, the right sense of balance, and in the ultimate analysis will enhance proportionality rather than harshness. In applying these principles, the court has to weigh and evenly balance all of them in determining the appropriate sentence it seeks to impose. None of these factors should be overly or duly emphasized above the other by the court. It is also accepted that the sentence which is to be imposed should be blended with mercy, because mercy is an element of justice itself. The personal circumstances of Mr. Manana were placed before this court by Mr. Bull. Mr. Manana is 33 years old, he is single, and has no children. Prior to the offense in question, he held the position of Deputy Minister of Higher Education and Training for a period of 5 years, from which he resigned as a result of this incident. He is currently a Member of Parliament of the Republic of South Africa with a reduced salary. He has a foundation called Mduduzi Manana Foundation, established in 2013, which focuses on education and early childhood development. The foundation also partnered with Vodacom to assist scholars from disadvantaged background in the science, technology, engineering, and mathematics program called STEM. He takes full responsibility for his action on the victims, and as such took it upon himself to seek counseling at the Body and Mind Counseling Center, to work on his anger management, resentment, guilt, and shame. The program at the said counseling center was for a period of 4 September 2017 to early weeks of October 2017. He is currently attending counseling session in accordance with the recommendations set out in the probation officer's report. He has also joined the Kuluma in Doda program, which is a community-based functioning organization with a focus on men and boys who voluntarily want to be helped to stop committing acts of gender-based violence and domestic violence. He has no objections in paying towards the victim's total medical cost, amounting to 26,680 Rand and 46 cents. He has on more than one occasion indicated that he still wants to make good out of the wrongs that he had done. He has 2 previous convictions of theft recorded on the SCP 69 for the years 2004 and 2005. These records date back to over 10 years ago. In the review judgment by the Honorable Slopper JP, at Samela in the Western Cape High Court, Cape Town, with review number CU /2115/2011 at page 3, the last paragraph. Open quote. An important consideration is to what extent is it permissible to take previous conviction into account when determining the imposition of an appropriate sentence. Ngobo J in Magur case Supra at 418J to 419J clearly sets out the guidelines to be followed. It is important, useful, and relevant to set them out in full. Point 1. In terms of Section 271, subsection 4 of the Act, the court is required to take previous convictions which have been proved against the accused into consideration when imposing a sentence. Point 2. In terms of Section 271A, previous convictions automatically fall away as previous conviction after the expiration of a period of 10 years from the date of conviction, unless the conviction relates to an offense for which the punishment may be a period of imprisonment exceeding 6 months without the option of a fine, or the person has been convicted of an offense for which punishment may be a period of 6 months imprisonment without the option of a fine during that period. This section does not merely provide that such previous convictions should not be taken into consideration when sentence is imposed, but it specifically provides that they fall away as previous conviction. Reference is made to S versus Zondi, 1991, Volume 1, SACR 18, A at 23, G to J. In terms of Section 271A, or capital A, the sentencing court has no discretion. It cannot take into consideration any previous conviction which fall within the purview of the section. State versus Zondi Supra. Although Section 271 subsection 4 requires the sentencing court to take previous convictions into account when determining the appropriate sentence, it does not take away the discretion of the sentencing court. The court is enjoined to exercise its discretion judicially when taking into consideration previous convictions. In the exercise of its discretion, the sentencing court is required to have regard to the nature, the number and extent of similar previous convictions, and the passage of time between them and the present offense. The relevance and importance of those convictions depends upon the element they have in common with the offense in question. And a reference was made to S versus J, 1989, Volume 1, SA 669, A at 675, C to D. The above was point 3 and point 4. And now I'll move on to point 5. Point 5, previous convictions which bear no relationship whatsoever to the crime are relevant in a limited sense only and simply with a view to determining to what extent, if any, the forms of punishment imposed for those crimes served as effective deterrence for the person in his or her career of crime, and also to indicate to which the person has an uncontrollable urge to lawlessness which reduces the chances of reform. S versus J Supra at 675. Point 6. The tendency of taking everything that appears on the form SAP 69 into consideration, regardless of the passage of time, must be avoided. It must also be borne in mind that even a criminal is entitled to ask that the lid on the distance should be kept tightly closed, S versus Mkwati, 1985, Volume 2, Essay 22, T. Point 7. The degree of emphasis to be placed upon previous conviction is a matter which is within the discretion of the trial court, where the degree of emphasis is disturbingly inappropriate in that it cannot be said that the sentencing court exercised its discretion judicially, the Court of Appeal will interfere. And I close quote there. In Kazu, Mr. Manana has been convicted on 3 counts of assault with intent to do grievous bodily harm. The 2 previous convictions of theft, and as I've mentioned, happened over 10 years ago. The crimes of theft and assault with intent to do grievous bodily harm bear no relationship. The court, by applying the principles set out in the said quoted cases, will not place much emphasis on the previous conviction. For the purpose of considering an appropriate sentence, the court will have regard Mr. Manana as a first offender. Assault with intent to do grievous bodily harm is a very serious offense and is prevalent in this court's area of jurisdiction. This act constitutes a serious violation on a person's body and right to dignity, as stated in the Constitution of the Republic of South Africa, 1996, at Chapter 2, Bill of Rights, specifically at point 10 of that chapter, where it's stated everyone has inherent dignity and the right to have their dignity respected and protected. Further, it was a rather cold, violent, degrading, and inhumane acts committed on 3 defenseless female victims. All 3 victims sustained injuries as a result of this crime. It is trite that females require protection from abuse, and there are many awareness campaigns run by government and society highlighting abuse against women and children. The crime was committed during Women's Month, and Mr. Manana, as a cabinet member of government at that point in time, should have been mindful of that. The facts on record show that the incident occurred in a restaurant, being a public place in the presence of other people, thus resulting in the victims being placed in an embarrassing and awkward situation. It was degrading for them as women to have experienced such a violent act. It is common cause that the victims approached Mr. Manana and had provoked him by referring to him as Istaban, which is derogatory in nature. But this did not entitle him to do what he did. According to Mr. Bull, the consumption of alcohol played a part in Mr. Manana committing this crime, and had he been sober, he would have acted otherwise. Mrs. Smith argued that consumption of alcohol constitutes an aggravating factor in committing this crime. The court, however, cannot lose sight of the circumstances under which the act had occurred, in that it was not premeditated. But this alone does not make the crime any less serious. It has been observed by this court that this case has sparked wide media coverage and public interest owing to the high-profile status of Mr. Manana at the time the offense was committed. The application by media to have these proceedings recorded by way of video and audio recording shows national interest by members of society. Mr. Manana held a position in government and was supposed to be a role model to our youths and further generations. It is the communities themselves that look up to our courts to see to it that justice is not only done, but seen to be done. It is for that reason that our courts have a huge responsibility in striking a balance when it comes to taking the community in its confidence. It is tried that many criminals go through our criminal justice system being convicted of this type of crime in our courts on a daily basis. The community need to take comfort and feel safe knowing that through the imposition of sentences by our courts, that something is being done about the increase of violent crimes that are being committed by criminals. It is not expected of people in Mr. Manana's position to take the law into their own hands without having regard to any consequences. The law enforcement agencies like the police and the courts are there to ensure the peaceful coexistence of people everywhere. The probation officer, Mrs. Masisi Modicone, dealt with the victim impact statement in a report from pages 10 to 13. In respect of the victim, Ms. Noluntando Maslaba, it was stated that although she suffered minor injuries, she felt humiliated and was disappointed by Mr. Manana's behavior, especially from a position of Deputy Minister of Education and Training. She felt traumatized and unsafe. This incident caused the emotional pain. This is going to be a stigma that is going to last forever, and in the future of children will know about it. She has learned the lessons of not insulting and labeling people. The accused has anger management issues which needs to be addressed. She indicated a need for professional counseling and a compensation of 100,000 rands. A claim was quantified in the amount of 5,014 rand and 20 cents. In respect of victim number 2, Ms. Mandisa Duma, she suffered physical injuries. She was angered by Mr. Manana's behavior as they were initially introduced to him by a father, Mr. Duma. Injuries required medical attention, and the medical expenses incurred amounted to 11,869 rand. She felt humiliated and stripped of her dignity because during this fight, a body was exposed as being half naked in a public place. She further had to endure negative comments from people through social media. She had to reduce her interaction with others at the workplace in order to avoid embarrassment. The victim indicated she would need counseling sessions to get over this ordeal, and in addition, compensation of 100,000 rand. A claim was quantified in the amount of 20,263 rand and 34 cents. In respect of the victim number 3, Ms. Tina Mapipa, she lost her shoes during the commotion. She suffered minor bruises on her face and is experiencing headaches. She was advised by a treating doctor to consult with a neurologist or a psychiatrist. She reported humiliation and stigmatization by the public and was requesting compensation in the amount of 100,000 rand and requested to be referred to for professional counseling. A claim was quantified in the amount of 1,403 rand and 92 cents. It is clear from the victims that the commission of the offense had a negative and traumatizing effect on them. It was humiliating and embarrassing. It was a humiliating and embarrassing situation for them as women to have been subjected to. This incident in the minds of the victim will not easily go away. As pointed out by them, they will need professional help. This shows the serious gravity of the situation that they are now placed in. The traditional purposes of punishment are deterrence, prevention, retribution, and rehabilitation of the offender. In the case of S versus Banda and others, 1991, Volume 2, Essay 352BG, at page 354, Friedman J. stated, open quotes, point 1, deterrent, this may be general, that is, discouraging others that the accused from committing the crime. No, I'll just repeat that, discouraging others than the accused from committing the crime. Special, discouraging the specific offender from doing it again, or both. Point 2, preventive, to protect the public from further criminal conduct by the accused. This may arise out of incapacitation as a result of confinement to prison. Point 3, reformative, concerning the rehabilitation of the offender by educational or other correctional treatment in the most effective manner. Point 4, retributive, the exaction of a penalty which reflects the seriousness of the offense to promote respect for the law and to provide appropriate punishment for the offender. And a close quote there. In State versus Sinden, 1995, Volume 2, SACR 704, it was the Appellate Division decision. The Honorable Funder EFA AR stated at page 709A to B, open quotes, a sentence does more than deal with a particular offender in respect of the offense of which he has been convicted. It constitutes a message into the society in which the offense occurred. And a close quote there. The most common types of sentences used by our courts on a daily basis are the imposition of a fine, imprisonment, and correctional supervision. In the book of Imstra Criminal Procedure at page 28-27, paragraph 3, open quotes, imprisonment can be defined as the admission into a prison and confinement of an offender in a prison for the duration determined by the court, or in some instances by statute. Section 36 of the Correctional Services Act 111 of 1998 reads, it's Section 36, objective, or it's titled Objective of Implementation of Sentence of Imprisonment. With due regard to the fact that the deprivation of liberty serves the purpose of punishment, the implementation of a sentence of imprisonment has the objective of enabling the sentenced prisoner to lead a socially responsible and crime-free life in the future. Close quote. At paragraph 5, open quotes, it is without doubt a very severe punishment to be deprived of personal liberty and locked up in a prison. That is as it should be. Those who commit serious crimes should be punished severely. It is also right and proper that the community is protected from villains. It is for that very reason, however, that imprisonment is inappropriate for less serious transgression. Further on in the same paragraph, in the case of serious crimes, society's sense of outrage and the deterrence of the offender and other potential offenders deserve considerable weight. Imprisonment is preeminently designed to fulfill the functions of deterrence. And a close quote there. Both the defense and state were in agreement that Mr. Manana should receive a term of imprisonment, but that such sentence should be suspended for a period of 5 years on condition that he does not commit the offense of assault with intent to do grievous bodily harm during the period of suspension. The probation officer, as part of a recommendation, also confirmed the same sentence as advanced by both the state and the defense. In the book of Imstra Criminal Procedure at page 28-33, paragraph 5, open quotes, correctional supervision caters for the person who has to be punished but does not have to be removed from the community. The Appellate Division confirmed in State versus Ingram, 1995, Volume 1, SACR 1A at 9E to F, that correctional supervision is appropriate for any offense for which punishment without removal from the community is appropriate. There are many examples in the law reports in which this form of punishment has been applied to virtually the entire spectrum of crimes. The advantage of correctional supervision is that it aims to punish and rehabilitate the offender within the community context. The offender's work routine are left untouched, and the obvious negative influences of prison are avoided. Close quote. Both the defense and state agree that as part of sentence that Mr. Manana also receives correctional supervision. The defense has to a great extent agreed with the recommendations set out in the report of the probation officer. The state, on the other hand, placed every reliance on the recommendation made by the correctional officer to include house arrest. The victim, Ms. Nolentando Maslaba, in an impact assessment report, believes that Mr. Manana is having some anger management issues that needed to be addressed. In the book of IMSA Criminal Procedure at page 28-56, paragraph 2, open quotes, a fine is a punishment because it reduces that offender's financial means and can thus reduce his or her standard of living for a period of time. State in brackets, State versus De Beer, 1977, volume 2, essay 1610 at 163C. It is obvious that a fine imposed on a wealthy offender will have to be much higher than that directed at an indigent person. Close quote. And at paragraph 6, open quote, a fine should not be imposed if the offense is so serious that imprisonment is the only appropriate punishment for it. Close quote. Mr. Bill submitted that Mr. Manana will be able to afford a fine amount of 100,000 rands. Mr. Bill stated that Mr. Manana is currently receiving a reduced income. He stated that the payment of fine will account for 2 months of his salary, of which 40% has to go towards tax. He stated further that Mr. Manana has no other source of income other than that of being a member of parliament. In conclusion, Mr. Manana has pleaded guilty to the offense and he did not waste the court's time. Mr. Manana held the position of Deputy Minister of Higher Education and Training for a period of 5 years, from which he resigned as a result of this incident. He took it upon himself to seek counseling at the Body and Mind Counseling Center to work on his anger management, resentment, guilt, and shame. He is currently attending counseling session in accordance with the recommendations set out in the probation officer's report. This all indicates remorse on the part of Mr. Manana. Mr. Manana has further indicated his willingness to compensate all the victims. He further expressed regret and was willing to reach out to the victims after conclusion of his sentence. This further demonstrates remorse on his part. He has also joined the Kuluma and Daughter program, which is a community-based functioning organization with a focus on men and boys who voluntarily want to be helped to stop committing acts of gender-based violence and domestic violence. This shows that Mr. Manana is a productive and useful member of society. As I have stated earlier, the crime committed is very serious. The commission of the crime has changed the lives of the victims in a negative manner. The victims sustained physical injuries, felt humiliated, traumatized, and embarrassed. This incident has affected them in a manner which they will remember and carry for the rest of their lives. The community needs to feel safe wherever they are in society, be it in public places or restaurants, without having to worry about crimes of this nature and crimes in general. It is expected of this court to impose a sentence that would not only deter Mr. Manana but other would-be offenders from committing such a crime in the future. In addition to theories of punishment that are deterrence, prevention, retribution, and rehabilitation of the offender, the court has taken into account by balancing the accused's personal circumstances, the crime interest of the community, and impact of crime on the victims to arrive at an appropriate sentence. The court finds the appropriate sentence is as follows. All three counts are taken as one for the purpose of sentence. Mr. Manana is sentenced to pay a fine of 100,000 rand or to undergo 12 months imprisonment. In addition to this, Mr. Manana is to attend and complete the anger management program offered by Aki Sanang, Domestic Abuse Prevention and Training Perpetrator Program, in short, ADAPT. Mr. Manana is to complete 500 hours of community service to be rendered at the organization called Valued Citizen Initiative, with the hours and dates determined by the probation officer, Ms. Modikone. The said programs and community services rendered are to be closely supervised and monitored by Ms. Modikone. Mr. Manana is hereby ordered to report by tomorrow, 14th of November 2017, at 8 a.m. at the offices of Ms. Modikone for the implementation of the said programs and community services. In terms of Section 300 of the Criminal Procedure Act 51 of 1977, Mr. Manana is to compensate the following victims, namely Noluntanda Maslaba, an amount of 5,014 rand and 20 cents, Mandisa Duma, an amount of 20,263 rand and 34 cents, and Tina Mapipa, an amount of 1,403 rand and 92 cents. The compensation amounts are to be paid within 7 days after the passing of sentence into the bank accounts of the respective victims. Such banking account details are to be supplied by the state to the defense immediately after the passing of sentence and conclusion of the proceedings. As this offense involved a great degree of violence, the court finds that there are sufficient reasons to determine that Mr. Manana is unfit to possess a firearm. In terms of Section 103, subsection 2 of the Firearms Control Act 60 of 2000, Mr. Manana is accordingly declared unfit to possess a firearm. You may sit down, sir.